So, good day everyone. So, our topic is it's all about Republic Act number 10142 or an act providing for the rehabilitation or liquidation of financially distressed enterprises and individual. So, in chapter 1, general provision, section 1 is it's all about the official name of the law. So, it's called the Financial Rehabilitation and Insolvency Act or Fria of 2010. So, this law deals with how individuals or companies that can't pay their debts anymore and should be handled under the Philippine law. Next is Section 2. So, it explains the purpose and guiding principle behind the law. So, ang government, they recognize that sometimes people or companies run into a financial trouble. So, then they can't pay their debts anymore. So, but instead of just letting them fall apart or leave their creditors unpaid, kay ang law nag-encourage sila og a system where ang debtors at creditors kay maka-work together to find a solution. So, naatay two main paths under this law. So, first is rehabilitation. So, rehabilitation is this is when the goal is to help the debtor recover financially. So, it tries to fix the situation so the business can continue and eventually pay its debts. So, dili lang siya makatabang sa debtor but also the people they owe money to, or like atong creditors, employees, and even the economy in general. The next is liquidation. So, kaning liquidation is katunang ang recovery kay dili na siya possible. So, ang law, they allows for a fair and organized shutdown of the business. So, ang kanina process kay ang katong mga assets sa debtor like katong money, property, or equipment kay ilang ibaligya, then they will use that to pay off the debts as much as possible. So in Section 3, Nature of Proceedings. This section kay it talks about the kind of legal process used when someone applies for rehabilitation or liquidation under this law. So first, ang law, this says that the proceedings are in rem. So, unsa may pasabot sa in rem. So, it means ang kaso daw or ang case kay it's about the thing or property. So, dili na siya sa about sa specific person. So, it means that the court proceeding under the Fria is focuses on the assets or properties of the debtor. So, dili na siya sa arguments between specific individuals. So, because of this, anyone who has a legal interest in the debtor's property like atong creditors will be affected by the result even if they weren't directly named in the case. So, how does the court get authority over everyone involved man? So, under the FRIA, ang korte they gets jurisdiction or legal authority over all people who may be affected by the case once a public notice is published in a widely read newspaper. So, dili na sila need to notify every creditor one by one in the beginning. Once the notice is published properly, everyone who has claim or interest is expected to participate or to take note. So, how will the court handle the process man? So, ang law, this says the court should be handle the case in a summary and non-adversarial manner. So, summary. So, ang process daw kay dapat siya fast, then straightforward, not drag out like a full-blown trial with the long arguments and many witnesses. Then, non-adversarial. So, dili na siya about fighting or winning a case. So, ang focus is on cooperation, finding solution, and fulfilling the goals of FRIA, like saving the debtor's business or ensuring fair liquidation. Then, ang Supreme Court said they will issue a special rules of procedure to guide how these cases should be handled in court. So, next is Section 4, which is mga definition of terms lang siya. So, proceed ta sa Section 5. So, Section 5, Exclusion. So, this section it tells us kung kinsa tong dili siya covered by the FRIA. So, kinsa man ang mga excluded or not considered as debtors under the FRIA. So, first is banks, second one is insurance companies, next is pre-need companies, and last is national and local government agency or units. So, this means they cannot use FRIA if they get into a financial trouble. Instead, they follow different laws and procedures specific to their type. So, next is Section 6. Section 6. designation of courts, and promulgation of procedural rules. So, kanina section kay it gives the power to the Supreme Court to do the two important things. So, first is ang Supreme Court ang maka-choose sa court that will handle the Fria cases kay not all the courts in the Philippines will hear this case. So, the Supreme Court will pick the specific courts, usually mga regional trial courts, to focus on financial rehabilitation and insolvency cases. Second one is ang Supreme Court, sila ang maka-create sa rules that will be followed in these cases. So, ang kanan na rules kay may include the dira ko tong how to file, unsa na mga documents na need, how hearings are done, and other court procedures. So, this will be special rules separate from regular court cases, so the process is more suited to a financial matter. Section 7. Substantive and procedural consolidation. So, this section, it talks about how courts should treat companies involved with the same case, especially when they are connected or related. So, normally, manggod kaya ang each juridical entity like corporation is treated as a separate legal person, then their asset and debt stay separate from the others, even if ang ilang companies are part of the same group or owned by the same people, they treated as independent. But sometimes, ang law kay they allows consolidation. So, mo nang combining their assets and liabilities into one. So, wala tong gitawag og substantive consolidation, and it only allowed only if certain conditions are met. So, again, kanusaman kung may tabo ang consolidation. So, allowed siya only if at least one of the following applies. So, first is mix na daan ang assets and debt before the case started. Second one is ang two companies have common creditors and it would be more practical to treat them together in one case. So, kana makas-help to save time, avoids confusion, and may lead to a better outcome. Next is the related company kay they agrees to be included in this case and is willing to combine its assets and liabilities with the main debtor. So, mana itong tawag og voluntary decision to join the process. Last one is if ang combining the two companies' assets and liabilities kay maka-benefit ang tanan or for everyone, then makatabang siya to achieve the goals of rehabilitation. So, this might lead to a better plan for recovery and fair treatments for creditors. So, even if ang full consolidation kay dili siya allowed, ang court kay nagapon siya power to include other related entities in the case if ang Supreme Court's rules kay they permit it. So, this gives the court flexibility to make sure the process is fair and effective. Next is Section 8, a decision of creditors. So, ang kanina section, it talks about how creditors should make a decision during rehabilitation or liquidation. So, how do creditors make decision man? So, magdepende na siya sa kind of legal entity that involved. So, if ang debtor is corporation siya or stock or non-stock, then the creditor decision must follow the rules in the Corporation Code of the Philippines. Then if ang debtor kay na siya sa partnership, then ang mag-follow siya jud sa rules sa Civil Code of the Philippines. Then nasa tay condition ani. So ang kanina decision kay must not conflict with the Fria. If there's a difference between Fria and the Corporation Code or Civil Code, then Fria will prevail since special law for this situation. Next is Section 9, Creditors' Representatives. So, the law allows the creditors to choose a representative, so someone who can vote or act on their behalf in the proceedings. So, how do they do this, man? So, to make it official, they must file a notice with the court saying who their representative is. The second one is send a copy of the notice to either the rehabilitation receiver if sa rehabilitation case or the liquidator if sa liquidation case. So, this helps to make sure that the representative has the proper authority and that the process stays organized and transparent. So, next is Section 10. Section 10, kay it's about punishing certain individuals who try to cheat or harm creditors when they know that a financial rehabilitation or insolvency case is about to start. Then, ang law, they target the people who are in charge of the debtor's finance or property, such as individual debtors, owners of sole proprietorship, partners of partnership, directors, and officers of a company sa corporation. So, if kanang mga individuals, they know that the business is about to enter into rehabilitation or liquidation or already has, then they will intentionally do any of the following, then they will be held liable. So if magbuot sila baligya or magbuot sila giveaway sa debtor's property sa outside the usual business operation, like suddenly transferring land, vehicles, or money with no clear business reason, then buot sila approve or doing transactions that are meant to cheat the creditors or that are clearly harmful to the debtor or creditors, or like they try to hide the asset from the creditors or embezzling or misusing the debtor's money or property. So, if someone is found guilty of doing any of the above, then they will have to pay double. So, double the value of the property involved or double the amount of the transaction made, or whichever is higher. So, this money is recovered and given back to the benefit the debtor and the creditor. So, it's a way of restoring what was lost or stolen and punishing the bad behavior. So, in section 11, this section is about allowing banks to accept company share as a payment for unpaid debts, especially during rehabilitation or liquidation of a financially struggling company. So, ang main idea here is when a business or when a debtor goes through a financial rehabilitation or liquidation, it may not always be able to pay its debts with cash. So, instead of money or cash, it can offer something else, a part ownership in the company. So, again, this section, it allows the banks to accept shares in a company as a payment for those debts, even if other banking laws normally say they can't. So, all banks, whether they are universal banks or smaller banks, are allowed to do this, even if usual banking rules would normally prohibit it. So, ano sa man siya ma-allowed? So, this is only allowed if the exchange of the debt or for equity is a part of rehabilitation or liquidation plan that has been approved by the court. So, it's not just any deal. So, it has to go through proper legal channels and be approved by the court as a part of a solution to the company's financial trouble. So, nasa tayong mga condition and limits Okay, even though ang banks are allowed na to hold shares, they must still follow the maximum ownership limits set by the banking law. So, particularly those that apply to universal bank. Second one is ang bangko, they cannot keep this share forever. So, dapat ilan na ibaligya or dispose of the share within 5 years or within another period that the monetary board may allow. Section 12. Petition to initiate voluntary proceedings by the debtor. So, ang kanina section, it explains how an insolvent debtor can start the rehabilitation process voluntarily by the filing a petition in the court. So, it also tells us kung kinsay maka-approve ni kanina decision, kung sa na information ang include, o kanus ang groups can file together. So, again, who can file the petition? So, magdepende niya siya sa kind of business entity that debtor is. So, if sa sole proprietorship ka, ang owner dapat naka-approval sa owner. Then, if sa partnership ka, ang need nimo og approval from a majority of the partners. Then, sa corporation kay nakay two types of approval. First is majority vote of the board of directors or trustees. Second one is approval of at least 2/3 or 2/3 of the stockholders for stock corporation or 2/3 of the members for non-stock corporation in a properly called meeting. So, ang once kanang condition kay ma-met, then the debtor can file a petition for rehabilitation in court. But, the petition must be verified and it must be proved two things. So, first is dapat ang debtor kay insolvent siya, murag di jud na siya kabayad siyang utang na. Then, second one is ang debtor's business kay still viable and can recover through rehabilitation. Then, ang kanina petition kay must also contain several important details, either written document siya or attached to it. So, include the mga basic info about the debtor, like pangan, unsa na business type, ug unsa address sa debtor. Then, second one is a statement of the cause of insolvency, or nganong dili na siya kabayad sa mga utang. Third is kanang specific legal relief or unsa na klase na taba ang gipangayo sa debtor or sa business. Next is ang legal and factual grounds or basis for the petition. Next is any other information required depende sa relief na being requested. The next is katong mga list of debts and creditors including sa ngalan, address, pilang utang sa debtor, or na ba siya mga any collaterals or securities attached. The next is mga asset list or a full of inventory of assets including the cash, properties, receivables, claims against others. Then next is ang rehabilitation plan, of course. Then kani is kanang money ang plan showing how the business will recover, like cutting the costs or paying the debts over time. Then next is 3 nominees for the position of rehabilitation receiver. Ang kanang rehabilitation receiver is kanang someone who will help to manage and oversee the process. The next is mga any other required document as stated in Fria or rules from the Supreme Court. The question is, can a group of debtors file together? Then the answer is yes. A group of debtors like a parent company and its subsidiaries or closely linked business may jointly file for rehabilitation if one or more of them believe that they won't be able to pay their debts when due and the financial problem of one of may negatively affect the others, and their participation is necessary for the rehabilitation plan to work. Section 13, circumstances necessary to initiate involuntary proceedings. So, kanina section, it explain when a creditor or a group of creditors can legally force the debtor or the business to go through rehabilitation even if the business didn't ask for it. So first, dili lang siya or not just any creditor can file an involuntary petition. To do so, the creditor or group of creditors must dapat na sila total claim of at least 1 million or at least 25% of the company's capital, stock, or partner's contribution, or whichever amount is higher. So, ang kanina rule, kay it makes sure that only serious creditor with big enough stakes can initiate the case. So, once ang kanang creditor na ma-meet na nila katong minimum claim requirement, kay dapat nasa sila need to prove at least one of the following. So, first is there is no serious dispute about the debt, meaning or clear siya da o legally valid siya, and the debtor kay dili siya ka bayad sa required payment for at least 60 days or the debtor has generally failed to pay many of its debts on time, not just one or two. Or, ang kanang another creditor sa debtor, dili ang katong nag-file sa case, lain sang giutangan sa debtor kay has already started foreclosure on the debtor's asset like seizing the property or cover unpaid debts, and that action could either stop the debtor from paying other debts or make the debtor completely insolvent. So basically, if the debtor is obviously in financial trouble and the situation affects the creditor's chances of getting paid, then the creditor meets the minimum requirement, then they can go to the court and ask the debtor be placed under the court-supervised rehabilitation. In Section 15, action on the petition under the Financial Rehabilitation and Solvent Act or Fria. So, this section, it explain kung unsay metabo after ang creditor files the petition for rehabilitation in the court. So, once ang court kay na-receive nila katong petition, then nasa 5 working days to decide what to do. If ang court they find the petition to be complete and correct in the bold form like how it's written and substant or the mga important information it contained, then the court will issue the commencement order. So, mao na ang official order that start the rehabilitation process. However, if ang korte they find the petition is na missing something or like na siya mistake, then na siya option to give the creditor more time to fix the petition. So, the court can give a reasonable period for the creditor to either amend the petition, like make changes, or like mag-submit sila og additional documents needed to make it correct. So, if the petition is fixed or completely properly, then the court will start counting the 5 working days again, then starting from the day the amended petition or missing documents are filed. So this way, the clock will start and the court will issue the commencement order once everything is in order. Section 16. What happens when rehabilitation proceeding official start? So when the courts find the petition for rehabilitation proper, it issues the commencement order. So, muna ang official starts sa court supervised rehabilitation. So, this order contains mga kay instruction, legal effects, mga protection for both the debtors and creditor. So, mo ni mga dapat i-contain sa commencement order. So, first is identification. Next is ground for the case. Then, relief sought, mga legal effects. Then, next is official revocation status, like declares the debtor is now under court supervised revocation. Next is publication. Kani is mag-requires na to order to be published in the national newspaper once a week for 2 weeks, or starting within 7 days from when the order is issued. Next is notice to creditors or debtor. If the debtor filed the petition, kay nasa mga they must personally deliver a copy to any creditor who hold at least 10% of the total debts within 5 days. Then if ang creditor may file sa petition, then they must personally deliver a copy to the debtor within 5 days. Then also the appoint a rehabilitation receiver. Kanang court kay sila mo appoint sa rehabilitation receiver. So kanang person kay may or may not come from the list suggested by the petitioner. Then next, also the notify creditors to file claims, like list deadlines and the instruction for creditors to file proof of their claims at least 5 days before the initial hearing. Then also to notify BIR, direct it tells the Bureau of Internal Revenue or BIR to file its claims or comments against the debtor based on rules set by the Supreme Court. Then the next is continuous supply of goods or service, like it tells the debtor suppliers of goods or services that they cannot stop deliveries as long as the debtor pays for them moving forward. Also, the payment of admin expense, like it allows the payment of necessary expense like bills, mga salaries that come up during the revocation. Also, the initial hearing, so it sets the initial court hearing which must happen within 40 days from the day the petition was filed. Then the court will use this hearing to decide if the debtor really has chance to recover. Then the next is make petition available. So they make the copies of the petition or petition plan available for review or copying by any interested party. The next is document access. So it tells where the documents about the debtor and the proceedings can be viewed or copied. Then also other nomination for receiver. So it allows the other parties like creditors and even the debtor, if not the one who filed, to nominate someone else as a possible revocation receiver as long as they do at least 5 days before the hearing. Then also the stay or suspension order. So kanina part, it temporarily freeze the action against the debtor includes. So it includes the first is suspension of lawsuits. So it stops any ongoing or new lawsuits or process to collect debts. Next is second one is suspension of judgment. Like it stops the enforcement of any judgment, attachment, or other remedies against the debtor. Then third one is no selling or of property. So ang debtor kay they cannot sell or transfer any asset except in the ordinary course of the business. Last one is no payments of all debts. So debtor cannot pay pre-existing liabilities under the law allows it. Then in Section 17, the effects of the commencement order under the Financial Rehabilitation and Insolvency Act or Fria. So, kanina section, it explain kung unsa na legal effects may tabo once the court issues a commencement order. So, these are on top of the effects already listed in the stay or suspension order under the Section 16. So, mo ni may tabo. So, if ang rehabilitation receiver, katong person na mo manage sa rehabilitation process kay will now have the full power to do what the law allows, like i-review sa company's record, even ang katong mga bank accounts o mga other important document. So, but to do this, of course, ang receiver must first post a performance bond, like a form of guarantee that approved by the court to ensure that they act responsibly. So, Any attempt to collect or seize property or sell collateral aside of this court proceeding after the commencement order is issued is considered null and void. So, meaning kanang wala siya legal effect. So, ang kanina rule, it protects the debtor asset from being taken away while the case is ongoing. So, exceptions are allowed only if ang Fria or ang court kay they permits it. So, particularly, matakol ni siya sa Section 50. Then also, ang creditors cannot subtract or offset any debt they owe to the debtor against what the debtor owes them after the commencement date. So, any attempts to do this is legally invalid. Then, if someone's tried to create or enforce a lien like legal right over a property like mortgage or collateral after the commencement order, kay invalid siya. Then, all legal cases involving the debtor, whether they are filed by or against the debtor, must now be handled by the same revocation court. So, however, ang court they may allow some cases to continue in other courts if those cases were originally filed by the debtor. So, lastly, if anyone tries to take a legal action against the debtor outside this revocation process, then it can be considered an act of indirect contempt of court. So, which means the court can penalize them for not respecting the court's authority. So next is Section 19. It says that the debtor is temporarily excused from paying taxes, fees, penalties, interest, and the other charges owed to both the national government and local government units. So, kanina waivers last until either the revocation plan is approved or the petition is dismissed. So, this helps ease the financial burden to the debtors and support its recovery. Meanwhile, in Section 20, it explained that even ang government financial institution like land, bank, or DBP, they must also follow the court stays or suspension orders. So, that means they cannot continue with the legal action like foreclosure or collection against the debtor even if ilang mga own rules or laws says otherwise. So, i-ensure lang that all creditors, public or private, they treat the debtor fairly during the revocation period. Section 21, Effectivity and Duration of Commencement Order under the Financial Revocation and Solvency Act. So, once ang court, they issue the commencement order, then it will stay in the effect throughout the revocation process. So, unless ang court, they decide to lift it. So, ang kanina order kay ma-continue to protect the debtor as long as there are real chance that the debtor's business can still recover. So, to decide if ang revocation kay possible jud siya, then ang court, they look at as mga several important things. So, first is ang revocation plan, dapat kompleto ni siya. Then, it should follow the rules and include everything required by the law. Then, ang debtor's activity must be monitored well. The revocation receiver, a court appointed the person who oversee the process or katong mo manage sa revocation process, must be able to watch over the debtor's business to make sure ang creditors are protected. Then, ang debtor must try to talk to the creditors. Dapat mo make effort jud sila to meet sa katong mga creditors and to try to agree on the revocation plan. Then, ang receiver or ang revocation receiver kay motuo jud sila or must believe that ang plano kay ma-work siya. So, the revocation receiver should give a report to the court saying the plan is realistic, then na siya good chance for recovery. Even if ang plano kay dili ka siya perfect, then but ipakita gyapon sa revocation receiver that ang debtor kay na siya enough assets to support recovery, then na siya mga enough cash to keep the business running, then ang people na mo manage or the people managing the debtor like katong mga owners, directors are acting honestly and responsibly. Then the petition is not just a trick to delay the creditors, then the debtor has a workable plan to recover. So the petition documents must be truthful, they must not contain any false or misleading information. And also, if ang debtor kay they file the case, then they must have talked to the creditors who represent at least 75% of the total debts and try to get their agreement. Then if ang creditors may move ni filed sa case, then they must have talked with the debtor and made an honest effort to agree. No fraud or deception also. So the debtor must not have lied or tricked the creditors. Section 2 of the Fria outlines the actions to be taken by the court during the initial hearing of a reputation case. So, at this hearing, the court first determines which creditors have properly and timely filed their notice of claim. So, recognizing only those who follow the correct procedure. So, the court will also address any objection regarding the qualification or appointment of the rehabilitation receiver. If necessary, ang court kay mo appoint sila og new rehabilitation receiver in accordance with the law. So, additionally, ang court directs all the creditors to submit their comments on the petition and the proposed rehabilitation plan, requiring them to file this comment with both the court and the rehabilitation receiver within a maximum period of 20 days. So, lastly, ang court instructs the court instructs the rehabilitation receiver to evaluate the debtor's financial condition and to submit a comprehensive report on this evaluation within 40 days from the date of the initial hearing, as mandated under the Section 24 of this article. Section 24, Fria requires the rehabilitation receiver to submit a report to the court within 40 days from the initial hearing. Then, this report must contain the receiver's preliminary findings and recommendation, then regardless of whether the creditors have submitted their comments. Then, ang report then should address several key points like whether ang debtor is insolvent, the cause of such an insolvency, then whether any unlawful or irregular acts were committed by the owners, partners, directors, or officers that may have contributed to the insolvency. Then also, whether ang katong assumption, financial goals, and the procedures stated in the petitioner's rehabilitation plan are realistic, feasible, and reasonable. Also, whether there is a substantial likelihood that the debtor can be successfully rehabilitated. Then, whether the petition should be dismissed also, and whether the debtor should be instead be dissolved and or liquidated. Then, ang kanila report is crucial in guiding the court decision on the future of the debtor. Section 25. Fria provides the court with the three options upon receiving the rehabilitation receiver's report, so which must be acted upon within 10 days. So first, the court may give due course to the petition if it finds that the debtor is insolvent and there is a substantial likelihood for successful rehabilitation. Second one is the court may dismiss the petition if it finds the debtor is not insolvent, that the petition is merely a sham to delay the creditor's right, that the petition or rehabilitation plan contains materially false or misleading statement, or that the debtor has committed acts of misrepresentation or fraud against creditor. So last one or third one is the court may convert the proceedings into liquidation if the debtor is insolvent and there is no substantial likelihood for rehabilitation based on rules to be issued by the Supreme Court. So, kanina's section is critical in determining whether the rehabilitation case proceeds or ends or shifts to liquidation.